Objection to that motion right there, Your Honor. I didn't refuse counsel. They've refused me.
Them not telling you what you want to hear is not the same as being ineffective, okay?
Out of the 5, 2 of them never even called me. I never even was aware that they were appointed to me, and they never even emailed me, called me, nothing. There was no mail, nothing. I wasn't aware that even 2 of those 3 came forward. On record, I want this noted, that they are all workers of this city, and that they do not want to help me in this matter.
Well, Mr. Bishop, quite frankly, I'm a little tired of your conspiracy theories that everybody's out to get you or force you to do things. No attorney that's ever practiced in front of me has forced an individual to accept a plea.
I have video
Nor
record.
Mr. Bishop, it's my turn to talk.
Sorry.
At least one of the motions to withdraw, there have been allegations of verbal abuse by the defendant towards their attorney.
This man has come to court representing himself, and the hearing quickly turns into a difficult situation for him. From the very beginning, it's clear that things are not going smoothly. The atmosphere in the courtroom feels tense, and many people there seem tired of the repeated arguments he keeps making in an effort to get the case dismissed. What makes the situation even more unusual is that he has already worked with several different attorneys, but continues to place the blame on others instead of taking responsibility for the situation. He also keeps suggesting that the legal system is somehow working against him, which only adds more tension to the hearing. As the discussion continues, it becomes clear that patience in the room is starting to run out. Moments like this can be frustrating for everyone involved. Court hearings require time, preparation, and resources, and when someone repeatedly challenges the process in unproductive ways, it can slow everything down. Judges and court staff often have many cases to handle, so situations like this can make the process even more difficult. Watching the exchange unfold, you can feel how serious the moment becomes. The courtroom is trying to move forward, but the ongoing arguments keep getting in the way. It raises an interesting question about how courts should respond when someone continues to challenge the process like this. What do you think courts should do in cases like this? Share your thoughts and opinions. Now let's continue and see how the rest of this hearing plays out.
Now, at this time, I am going to grant the motion to withdraw, and Ms. Ilola, if you would like to leave, you're free to go.
Thank you, Your Honor. Before I do, though, I do want to make a record. Mr. Bishop did hand me a lot of materials to look over, which I did do so for his case. I would like to hand them back to him on the record, just so that way we do not have any further issues going forward. This is everything, including the flash drives that were given to me, and then including the new motions that were addressed, or this is the motion to withdraw that was sent to you also, but I wanted to give you a copy of it in person as well.
And Mr. Bishop, are you satisfied that Ms. Ilola has returned everything that you had provided to her?
I believe so, Your Honor, with a quick glance over.
Very well. Counsel?
Your Honor, I just wanted to make sure, clarify, does that include all the discovery provided by the state?
I believe so. Based off of what I was given by Mr. Bishop, I believe that's all the discovery as well.
All right. Thank you, counsel.
Thank you very much, Your Honor.
Okay, so a couple of matters that we need to address. Number one, the defendant, pro se, prior to the withdrawal of Ms. Ilola's counsel, filed a motion to enforce. That was filed on the 16th of January. In essence, the defendant is asking this court to order a different court to take legal action. This court has absolutely no authority to do that. Certainly, the defendant could seek a writ of mandamus from the Ohio Supreme Court, asking it to order the Domestic Relations Court to proceed. But
Repeat
this,
that? I barely can hear you. I'm sorry.
well, here's the thing. This court does not have any authority to tell another court what to do, all right? So I'm going to deny your motion to enforce. Now, there are certain other steps that you can take to try to get the relief that you sought from this court, but obviously that's something that you would have to do at this point on your own. Now, the other thing that was pending, and has been pending for a while, is the defendant's motion in limine regarding the use of a recording which purports to capture a conversation between the defendant and at least one, if not several, individuals at the Domestic Relations Court. The allegation being that the recording itself was made not by Mr. Bishop or the individual that he was speaking with, and in fact the state seems to concede that fact in its memorandum contra the motion to limine. And the court did considerable amounts of research yesterday afternoon, and here is basically what I found. Normally, a statutory violation is not remedied by exclusion. For instance, if an officer stops an individual for operating a vehicle while impaired outside of their territorial jurisdiction, that's actually a violation of law. But because it's not a constitutional violation, a defendant would have absolutely no relief or recourse to seek any type of exclusion. Now we need to address the issue of counsel, or maybe we probably should have done that first. It doesn't really matter because the last time we were here, when Mr. Iteum withdrew his counsel, the court did indicate and explain to Mr. Bishop that I would be reaching out to the Ohio Public Defender's Office to see if they would be willing to represent him. Thankfully they were, and I explained to him that if they weren't, or if that didn't work out, that the court would very likely declare what's called a constructive waiver of counsel. So I've done a little research in that regard as well. There's a case out of the 5th District actually from April of last year. It's in re adoption of AMV. It's 2024 Ohio 1240 is the site. But basically it talks about the fact that in that case, 2 separate attorneys were appointed to represent the defendant in a parental rights matter. The rights are conveyed under a different authority than the constitutional, but it's pretty much related. And then after the putative father basically fired both of those attorneys, the court reached out to every other attorney on that county's court-appointed list, all of whom declined to represent the putative father. And the ultimate ruling was that the defendant had 2 options at that point. He could, A, hire his own private counsel of his choosing, or B, represent himself. But at this point, the court finds that it has done everything possible to afford Mr. Bishop his right to court-appointed counsel, but that if 2 were enough in that particular case, I think 5 is more than enough in this one. So the court is going to declare a constructive waiver of the right to court-appointed counsel, and I will explain to you, Mr. Bishop, that you have 2 options. Number 1, you can hire your own attorney using your own funds. Number 2, you can represent yourself. You understand that those are the 2 options you have?
Yes, Your Honor. May I have a chance to speak now?
You can almost sense that he's about to say something that will make the situation even more complicated. But before getting into that moment, it's important to remember that this case is not about a small traffic issue. He is actually facing serious allegations related to violating a protection order and making inappropriate contact through school communication systems. Because of the seriousness of those claims, the court is paying very close attention to how the hearing is handled. Another surprising detail is that he has already gone through several different lawyers during the process, changing attorneys that many times raises questions about how the case has been handled up to this point. Eventually, he chose to represent himself, which is something people are legally allowed to do under the ruling of Farida versus California. However, choosing to represent yourself also means taking full responsibility for understanding the courtroom process. While the court respects a person's right to speak on their own behalf, that doesn't mean the judge must allow endless delays or repeated disruptions. Hearings are meant to move forward in an organized way so that the facts can be addressed and decisions can be made. When someone constantly shifts the focus away from the actual case, it can slow everything down and make the process more difficult for everyone involved at this stage. It almost feels like the man is pushing the limits to see how much the system will tolerate before stronger action is taken. Instead of helping his situation, this approach seems to be creating more tension in the courtroom as the hearing continues.
I need to advise you of the perils of self-representation. I want to confirm with you that you did not go to law school, nor do you hold a law degree, correct?
Correct.
You've never been admitted to the bar of any state to practice law, correct?
Correct.
Well, here's the thing. If you elect to represent yourself in these cases, you will be held to the same standard as somebody who has been to law school, who has passed the bar, and who has the experience of practicing in the courts of Ohio. The court would not be permitted to advise you on how to proceed. You could very well miss certain opportunities to improve your circumstances or plead your case. And that would be a risk that you would be taking by the fact of refusing to accept the assistance of court-appointed counsel.
Objection to that motion right there, Your Honor. I didn't refuse counsel, they've refused me. I would like that worded correctly. Sorry.
Well, Mr. Bishop, here's the thing.
They have all told me.
Here's the thing, Mr. Bishop.
Yeah.
Them not telling you what you want to hear is not the same as being ineffective, okay?
That
You may disagree with what they have to tell you, but they know more about the law than you do. I'm fairly confident in saying that.
That wasn't the case, Your Honor. I was being forced to take a plea deal when I wanted to come to trial. That is illegal. That is against my judicial standards of right. Every single attorney you have given me so far has told me to take the disorderly conduct on this telephone harassment and they'll dismiss the VPO. And every single one of them has told me this plea deal that they are going to come to the prosecutor with and that they want me to take that. And I have said, no, don't you dare go to the prosecutor with that. I want a trial, and that's what I want. And they have all came up with this phenomenon of a idea. Every single attorney. And when I say absolutely not, I want a trial, let's prepare for trial, next thing you know, we get a withdrawal motion. Me and her didn't have no quarrel. She just put her efforts into a rape case over me. And that's the same thing with that Ed guy. He put that whole situation, same thing with the previous attorney, Todd, or what have you, his name. And then I also want to put on the record, Your Honor, that out of the 5, 2 of them never even called me. I never even was aware that they were appointed to me, and they never even emailed me, called me, nothing. There was no mail, nothing. I wasn't aware that even 2 of those 3 came forward. All I knew about was Zach Tabler, Atilium, Todd something, and this Ariel Iolia, and that is it. 4 attorneys. That is it. The other one, and you had told me last time we came that there was 2 or 3 of them that withdrew themselves, Your Honor. I've never even seen or talked to them. I didn't even know they were my attorneys appointed. So, on the fairness side of things, I have not had fair representation, so I do want that to be put on the record that I have not had appropriate representation. That's why we've went through so many of them. And there was a $20 million lawsuit against the previous magistrate in this county, and all of the attorneys are aware of it, telling me, on record, I want this noted, that they are all workers of this city, and that they do not want to help me in this matter.
Well, Mr. Bishop, quite frankly, I'm a little tired of your conspiracy theories that everybody's out to get you or force you to do things. No attorney that's ever practiced in front of me has forced an individual to accept a plea.
I have video
Nor
record.
Mr. Bishop, it's my turn to talk.
Sorry.
At this point, the judge finally decides to step in more firmly and push back against the constant complaints. Sometimes people enter a courtroom expecting sympathy while ignoring the seriousness of the situation they are facing. When that happens, judges often have to remind them that the courtroom is a place for facts, responsibility, and clear decisions. The man begins arguing that he felt pressured into accepting a plea deal. However, the charges being discussed are quite serious. They involve violating a protection order and using a school communication system in a way that the court had already restricted. Situations like this naturally draw strong attention from prosecutors because the court's previous orders are expected to be followed carefully. In many cases, a plea agreement is actually offered as a way to resolve a case with a lighter outcome than what might happen at trial. It can provide a chance to settle the matter more quickly and with fewer penalties. That's why rejecting or mishandling such an offer can sometimes create bigger problems later in the process. Looking at the situation from that perspective, it seems possible that he made things harder for himself. Instead of improving his position, his decisions may have complicated the case even further. Moments like this show how important it is to understand the seriousness of legal proceedings and approach them with careful thought and preparation.
Nor have I ever accepted a plea that wasn't knowing, intelligent, and voluntary. That's why you saw me go through those questions with the 2 individuals who did in fact enter pleas in their cases before we called your case to be heard today. I will put on the record that in at least one of the motions to withdraw, there have been allegations of verbal abuse by the defendant towards their attorney, and there have been informal allegations that perhaps there may have even been threatening language used towards those attorneys. So the defendant's objection is noted, but he has waived his right to have court-appointed counsel by basically plowing through these attorneys. And whether it's 5 or whether it's 3, I can't get anybody else to accept representation of you, Mr. Bishop. Now, certainly, you've indicated that you want to have a trial, and the court is more than prepared to afford you that option. And after today, we will be scheduling this matter for a trial by jury. The court will make a determination as to which case we're going to handle first, because I do not believe these are consolidated, are they?
They are not consolidated, Your Honor,
Your
however.
Honor, can you explain what consolidated means?
Meaning they would be heard together at the same time.
They are not consolidated at this juncture, however, we would be able to try them both at the same time.
Well, the court finds that they're two separate and distinct matters, and in the interest of safeguarding the defendant's rights against undue prejudice, I do believe that they're completely unrelated in that one involves an allegation of a harassing phone call to court personnel, where the other simply involves an allegation that a phone call was made to a school where the defendant's children were enrolled, but that he was subject to allegedly a protection order that prohibited him from contacting the children's school. So the state certainly is welcome to file a motion to consolidate, but as former Judge Harris of the Fairfield County Municipal Court said, although I won't prejudge anything, you'll lose. That being said, we will schedule this matter for trial probably within about the next 30 days, Mr. Bishop. If you, in fact, retain private counsel, by all means, make sure that they submit their notice of representation in a timely fashion. If you elect to represent yourself, if there were ultimately a conviction on either one or both of these charges, you would certainly have the right to appeal my decision declaring a constructive waiver of counsel to the Licking County Court of Appeals. What was it you wanted to say?
Thank you, Your Honor. I'm sorry. If I don't speak, I lose it. So I'm not my father, so I'm not a professional, as you said. So I'd like to just make a motion right now. I was under the impression we were going to trial today, and that is what I came here prepared 100% for a trial today for the VPO. I am going to ask for a continuance and ask that we push the telecom harassment out for a few months, because I do want to retain counsel. I'm going to sell my father's Mustang and retain counsel. So it's going to take me at least a little while, and I'm in school right now at C-Tech for 5G broadband. So and it's already paid for. I've already put $2,200. This case is over a year. My life doesn't stop. I've got kids. I got child support. I have to work, and I got to go to school. So I'm asking that my graduation is after March 20th. We've pushed this out this long. I ask that if we do the telephone harassment, that we do that one past March 21st, so I can graduate. As for the VPO, I would like to make an oral motion right now and agree to your waiver to counsel for myself, and I don't need appointed counsel. I will represent myself on the separate matter of the VPO, and let me get the case number for you, Your Honor, for the record. Do you want me to stand on this, Your Honor?
You don't need to stand when you address the court. That's all right.
I would like the case number 23 CRB 1774A to note that I will represent myself on the VPO.
Okay.
And that I am going to request today as well an oral motion of dismissal, because I was under the impression of a trial today. I am prepared for trial. If state is not prepared for trial today, I ask that they withdraw and dismiss.
All right, Ms. Yeager?
Your Honor, Mr. Bishop speaks prematurely about our preparedness. However,
So his argument now is that he thought today was supposed to be the trial, and because of that he arrived without any evidence or preparation. From his perspective, it almost sounds like he expects the court to stop everything and simply reset the process. But that's not how the legal system works. Court schedules and procedures follow a strict structure, and a misunderstanding about the date doesn't automatically erase the case. The situation becomes even more serious when you remember that the charges involved are not minor. Yet he's acting as if a simple mix-up about the schedule should solve the problem and allow him to walk away without consequences. That kind of reasoning doesn't carry much weight in a courtroom where preparation and accuracy matter a lot. You can also see the reaction from the prosecutor during this moment. Her expression makes it clear that she has very little patience left for the repeated arguments and delays. The tone of the conversation suggests she is ready to move forward and address the case directly rather than entertain more confusion at this stage. It doesn't really seem like a misunderstanding anymore. It begins to look more like a strategy to slow things down, but it's not helping his situation at all. If anything, this approach may be making the case even more difficult for him as the hearing continues. School.
In speaking with court staff yesterday, we were instructed to call off our witnesses for the VPO case. So we would be unable to proceed, but we did that based on the impression that this matter would not be going forward today. Regarding...
Objection.
I'm
I
not
do
You have to
I'm
let
not-
her talk, Mr. Bishop.
Regarding the pushing the telecommunications harassment case to after March, we would object to that. These cases are from 2023. This has already gone on long enough. The defendant has a right to a fair trial, but the victims also have a right to a speedy trial as well. So we would object to just pushing that just so that he can graduate and sell his father's Mustang. Those are things that he should have already been prepared for. And since he did mention a disorderly conduct, we did want to just clarify for everyone, the state's offer has never been for a disorderly conduct. The state's offer has always been plead to the telecommunications harassment, and we would dismiss the protection order violation case. That's still what our offer is. However, if we do go to trial, we will be prepared to go to trial on both. Thank you.
Alrighty.
Your Honor, that didn't address my motion to dismiss.
And we are not dismissing.
Well, I was going to say, she doesn't really have to address it if she doesn't want to, but... Okay, as far as your indication, Mr. Bishop, that you wish to waive your right to counsel in the 23 CRB 1774 case, I just need to go over this with you on the record in open court. You do have the right to be represented by a counsel of your choosing, by hiring somebody. You have the right to apply for court-appointed counsel, which you've done, and which the court has granted on numerous occasions in this particular matter. Obviously, the court was declaring a constructive waiver of counsel, but if you're affirmatively waiving that, we just need to put that on the record and have you sign off on it. Be advised, representing yourself exposes you to a number of pitfalls and dangers. Self-representation is never recommended by any court that I've ever known because laypersons do not always know exactly how the law works or what the law is, what procedure is, but you would be held to the exact same standard as somebody who was trained and who was licensed to practice law. Do you understand that?
Yes, Your Honor.
And as far as that's the protection order case, right?
Yes, Your Honor.
Yeah. As far as that's concerned, is it your decision to waive your right to counsel and to
Yes,
represent
Your Honor.
yourself? All right, I'm going to have the bailiff present you with the form entitled waiver of counsel. If that is indeed your decision, make sure you go ahead and sign off on that, please.
Make sure you read it, okay?
Yes, thank you.
For the record, Your Honor, it does state on that paperwork the maximum penalty. We've never went over that. No
Okay,
one has.
just to let you know, on both of these charges, the telecommunication harassment and the violation of protection order charges, they're first-degree misdemeanors. Each carry up to 180 days in jail, up to a $1,000 fine. They're also both what we call enhanceable offenses, which means if you were to plead guilty or be convicted of either of them, if you were charged with the same offense that you were convicted of here in municipal court, it could be filed as a felony-level offense and carry a potential prison term, but your exposure, as the charges stand here in this court, are up to 6 months and a $1,000 fine. Understand?
Yes.
All right. And the record should reflect that the court did advise the defendant after he signed, but does that change your decision to want to waive your right to counsel?
No, Your Honor.
On that case. Okay, so the
Not
court will
on
accept
that
the waiver.
case.
Okay, well, I'll go ahead and I'll grant the motion to quash without objection from the defendant. The other motion was to either quash the subpoena ordering magistrate co-conspirator to appear for purposes of testimony, or in the alternative, because he had some sort of a conflict this morning, allow him to appear in the afternoon. Do you want to speak to that, Mr. Bishop?
I would object to that. As the prosecution has already stated, we've pushed this matter out forever, and he is crucial for the VPO situation because of his November 7th, 2023 hearing. And he is a crucial, I believe the word is alibi to the, or notice of justice is what I read about.
At this moment, the situation becomes even more awkward. The man turns toward the prosecutor as if he's looking for help with the words he wants to use. He even asks whether alibi is the correct term, which makes the moment very uncomfortable to watch. You can almost sense how tense the room feels as everyone listens to the exchange. The prosecutor's reaction says a lot without her even needing to say much. It looks like she is doing her best to stay professional, but it's clear her patience is wearing thin. After dealing with repeated delays and arguments, she seems ready to move forward with the case instead of entertaining more confusion. The atmosphere in the courtroom also reflects the growing frustration. By this point, the man has already worked with several public defenders, and the situation has dragged on much longer than expected. When cases stretch out like this, it can create pressure on everyone involved, from the lawyers to the court staff, that what's happening here doesn't really look like a strong legal strategy. Instead, it feels more like the hearing has slowed down because of constant interruptions and uncertainty about basic courtroom procedures. Moments like this show how important it is to be prepared and understand the process before stepping into a serious legal setting. Eventually, there comes a point where someone has to recognize the reality of the situation. When a case reaches this stage, the best approach is usually to focus on clear facts and proper preparation, rather than hoping someone else will step in and fix the problem.
Which is why I pushed for the enforcement. But yes, his testimony on that date is crucial to my case, and that is why I believe he should be subpoenaed, because I have a right to face my accusers. He is one of my accusers.
Well, actually, the accusation is that you made a phone call, not that, I mean, you can't, I suppose you could attack the validity of a protection order, whether it was actually in effect at the time, but relitigating whether it should have been granted is not on the table. That's not relevant to the determination about whether or not you violated it. So I'm going to grant the motion to quash at this time unless the defendant can show with more specificity the relevance that Magistrate Kokensparger holds to the violation of protection order charge. So, and I want to say this as well. I think you issued the subpoenas in the 1774 case. And that's the one it should have been, and I put these two motions in the wrong file. Okay, so I'm going to go ahead and I'm going to grant both of the motions to quash. As I said, you can reissue your subpoena for our next court date, but you'll have to show with some specificity why you believe that the magistrate has relevant testimony to provide.
Well, my question to that, Your Honor, is the validity of my audio that I'm presenting on our trial date, because that is...
Well, I wouldn't, let me put it this way. If somebody subpoenaed my staff to produce a recording of court proceedings, I would not be the one who would authenticate it. It would be the person who created the recording. So again, this is something that you're going to have to figure out on your own, because I can't give you advice on how to proceed, but there is a means by which you can address the appropriate party to produce those materials. And again, that doesn't mean they're relevant, and that doesn't mean they're irrelevant, but it means you have to go about the proper channels and seek the proper sources for those things. All right?
All right, and then also final for my record, Your Honor, I would like open access to be able to speak with the prosecution, and so the VPO matter on case number 23 CRB 01774. Since they are separate matters, I would like to be able to have that line of communication between me and the prosecution open as is usual custom standard.
Well, you'd be surprised how frequently the prosecution fails to respond to emails and phone messages from actually licensed attorneys. So I can't force them to talk to you anywhere other than inside the courtroom, other than responding to any pleadings that you file. Certainly you have the right to contact them to see if they're willing to speak with you, but they're not required to prior to trial.
Absolutely understood.
Okay?
Yeah.
Anything else?
No, Your Honor.
All right, very well. We're going to stand in recess, and notice of the new court dates will be going out. It would be the court's intention to
The telecom is the oldest one.
yeah, that was what the court was going to try first, was the telecommunication harassment. But as I mentioned, the state's more than welcome to file a motion to consolidate, but I'm not inclined to grant that because I do find that it would be prejudicial to the defendant.
Oh,
Okay?
Your Honor, one more thing, just since he asked about open access to the prosecutor.
Mm-hmm.
I believe I indicated to Mr. Bishop last time when we were here with Mr. Atayam, and my position on that still stands. I will speak to him in court on the record, or I can speak to him in writing through email, just so that there's no miscommunication and no issues on either side.
Okay, very well. Thank you very much. Court stands in recess.
Can I get the email?
Yes, I emailed you.
Let me know if you'd like to see a follow-up on this guy, because he definitely stands out as a memorable character in the courtroom. Watching him is strangely entertaining at times, but at the same time it can also be exhausting. His constant arguments and behavior seem to keep the case going in circles, rather than moving toward a clear resolution. That IT also makes you wonder what his next step will be. After going through so many lawyers already, it's hard to imagine how much longer this pattern can continue. At some point, constantly changing strategies or representation doesn't solve the problem if the underlying issues are never addressed. What really stands out is how some people become convinced that the entire system is working against them. In many situations, though, the real challenge comes from refusing to accept responsibility or adjust their approach. When someone continues down that path, the situation often becomes more complicated instead of improving. This case also raises an interesting question about how courts manage difficult situations like this. Judges have to balance giving someone a fair process while also keeping the courtroom organized and preventing hearings from turning into long disruptions. Maintaining that balance can be a tough job, especially when a case stretches out over time. That I'm curious to hear your thoughts about how the judge handled everything. Do you think the situation was managed fairly, or should it have been handled differently? With so many lawyers already involved, it certainly feels like the case has gone on much longer than expected. Thanks so much for watching and following along with the discussion. Your support and opinions are always appreciated. Take care, everyone.